Okay, good morning everyone. Well, just about good afternoon. Thank you, Aslam, for the kind introduction. As mentioned, my name is Jessica Byrne, or as one of my colleagues now refers to me as Jessica Poppins, and maybe you'll agree after this presentation. So I'm going to be talking today about a prescription for the puppy syndrome, utilizing data whilst complying with new legislation. So, puppy syndrome. I've sort of played on a pretty well-known phrase, which some of you may know, tall puppy syndrome. It's something which emanates from Australia, and it's basically when someone has achieved something of significance, and they're therefore considered to be of higher status in society. However, they're resented and met with hostility because of that success, and they're basically cut back down to size to be like everyone else. So as you can imagine, I'm not here to talk about flowers or peculiar Australian culture. I'm here to talk about the Protection of Personal Information Act, sometimes referred to as PUPI. And basically, the idea is that a lot of companies over the last decade have been doing really, really well and have been thriving through the use of data. However, there is a perception and a fear that legislation like PUPI is going to come in and cut down and hinder growth potential for your business. So when I talk about data, in 2017, The Economist described data as the most valuable resource in the world, overtaking oil. And we can see this from the great data giants such as Google, Facebook, Amazon, American Express, Netflix, and many, many more. We can see how these data giants have just been thriving and doing really well. However, we're now also seeing that there's a global shift towards seeing data rights and digital rights as human rights. Companies are collecting a staggering amount of personal information, and greater attention is being placed on responsibility of those companies, both from an ethical and a legal perspective. However, this global movement isn't just being pushed by human rights advocacy groups and consumers. In 2018, two of the world's largest technology companies also recognized the significance of this movement. In 2018, Apple CEO Tim Cook referred to data privacy as a civil liberty akin to freedom of speech. 2 months later, Microsoft CEO Satya Nadella explicitly called data privacy a human right and said that industry should do more to ensure that technology is responsible and ethical. So in South Africa, we've got the introduction of the PUPI Act, as I've mentioned, and I'm basically here to sort of demystify some of the uncertainty and address some of the fear of companies about this new piece of legislation and what it could do. Yes, data rights of individuals need to be protected, but this doesn't mean that businesses can't tap into this extremely valuable resource. It just needs to be done in a way which complies with the law. So I think the first thing to point out is that the majority of the provisions of PUPI have not actually come into place yet. There are a few, one of which establishes the information regulator, and that's essentially the watchdog for PUPI to ensure compliance. Another provision allows for the regulations in terms of PUPI to be promulgated. These regulations in terms of PUPI came into effect in December last year. So with the establishment of the information regulator and the establishment of the regulations, we know that the general commencement date is on the horizon. Furthermore, once PUPI comes into place in its entirety, there will only be a 1-year grace period for companies to get their ducks in a row and ensure that their companies are compliant. So basically, I'm here today to help you start preparing with that process. PUPI is also bringing South African legislation in line with global standards. In Europe, we have the General Data Protection Regulation, which came into effect in May last year. So South Africa is really not that far behind. In the preamble of PUPI, it sets out that PUPI is rooted in the constitutional right to privacy, which again goes back to this idea that digital rights are human rights. In a nutshell, processing has to be done in a way which is lawful, done in a reasonable manner, and the purpose for which personal information is collected is relevant. Just to move on to some of the terminology in PUPI, We've got personal information, which is information which either relates to a living, identifiable natural person or an existing juristic person. It's an extremely broad and open list. It includes things that you would expect to find: names, ID numbers, physical addresses, email addresses, that kind of thing. It then moves on to more individual characteristics such as race, gender, marital status, pregnancy status. It includes history, so financial history, medical history, educational and employment history. It includes biometric information such as fingerprints, facial recognition, voice recognition. And then we come on to some of the more interesting ones, which are explicitly stated in POPI. Things like correspondence, which you've sent, views or opinions which you've expressed. And as I say, it's an open list, so really it can be added onto if it's within the same vein as those examples which I've given. You've got a responsible party, and that's the person who's doing the collecting and processing of data. You've got a data subject from whom the information is collected. You've got a processor in certain circumstances where a third party acts on behalf of the responsible party to process the information. And then you've got processing, an extremely wide definition. As you can see, I've got a whole list of verbs, which the Act lists. But basically, if I can nail it down to 4 things, it would be the collection, the analyzation, the sharing, and the storing of personal information. So then we need to consider, when does POPI actually apply? Because if what your business is doing doesn't fall within these requirements, you wouldn't need to be POPI compliant. So basically, the first requirement is that there needs to be processing of personal information, either done by automated or non-automated means. The personal information then needs to be entered into a record, and the responsible party either needs to be domiciled in South Africa, or the automated or non-automated means to collect and process the data needs to be based in South Africa. However, there are certain exceptions, and that's when you're processing personal information for personal or household activities. If you de-identify or anonymize the personal information, by definition, it is no longer personal information, and therefore you don't need to comply with the requirements in terms of POPI. Interestingly, we assisted a group of actuaries who were trying to see the correlation and algorithms between health data and credit data, but they realized that they didn't actually need to know who the individuals were to whom that information belonged. So just anonymized it, and yeah, good to go. Another exception is if the information is being used by a public body for national security purposes. And the last one I have there is where you're processing personal information for journalistic, literary, or artistic purposes. And this is where we see the age-old battle between the freedom of expression and the freedom of privacy coming into play. And basically, if there is a huge dispute, it's something that the courts have to work out for a judge to determine which right takes precedence in the specific circumstances. So there I have the 9 requirements for lawful processing. I should mention at this stage that you do want to be POPI compliant because the Act sets out very damning penalties for non-compliance. There is, you could receive an administrative fine up to 10 million rand if you're not compliant, and also the threat of imprisonment for a period up to 10 years. Obviously, those are extreme situations, but the Act does include those provisions. So the 9 requirements, you've got lawfulness, which requires the information to be processed lawfully in a reasonable manner in a way that doesn't infringe on the right to privacy. You've got minimality, and this means that the purpose for processing needs to be adequate, relevant, and not excessive. Purpose specification, the information collected needs to be for a specific, explicitly defined, and lawful purpose relating to the activities or functions which the responsible parties are carrying out. Then you have justification and consent. Basically, you need to be able to explain why you are processing this information and why you're allowed to do so. The easiest way to ensure compliance with this is to make sure your data subjects are, you receive the consent, informed consent of your data subjects. and that's a pretty way to ensure compliance there. However, the Act does provide that in certain circumstances you don't require consent, and that's if it's in the legitimate interests of your data subject or in the legitimate interest of the responsible party. However, it's an extremely high threshold to prove to the information regulator, so it's far better to just get consent. The information quality, it needs to be complete, accurate, and not misleading, and it needs to be updated on a regular basis. Then we've got the further processing limitation. So sometimes you will have collected data and you've used it for a specific purpose and you want to keep on using it. You need to make sure that that purpose is connected to the purpose for which you originally connected the data. Openness. Your data subjects need to be informed of the processing that is happening of their personal information and make that information freely available to them. Security safeguards. Hugely important. You need to ensure that personal information is kept confidential and that the information's integrity is maintained. You need to take appropriate steps to make sure that there is no loss, damage, or destruction of the personal information, and you need to guard against unlawful acts. If a data breach does happen, you have to be able to show the information regulator and your data subject that you took the reasonable steps to ensure that their personal information was kept safe. And lastly, data subject participation. You need to ensure that your data subject is able to confirm, amend, or update their personal information and also request you to delete it off of your system. There are also more stringent requirements for special personal information. I've listed a few of them there, but if there's trade union membership, political persuasion, if children are involved, for example, if children are involved, you need to get their consent of their legal guardian or parent before you can process their personal information. So, my prescription, I'm not a doctor, but hopefully I can give you a few practical steps to comply with the 9 requirements. Firstly, consider why have you kept and you are collecting information. You would want to go through your data and delete any data which you no longer think is in line with the purpose for which you originally collected it. You'd want to look at things like your customer and client forms and look at them carefully and consider, do you actually need all this information that you're asking for? Terms and conditions and data protection and privacy policies, which we can help assist in drafting at Adams & Adams. And this is basically where you're going to get your informed consent, because they're going to set out exactly what you're doing with personal information and how it's going to be used, stored, and if applicable, shared. In drafting those policies, we'd have to consider the special personal information and the extra requirements that go along with that. We'd have to include a revocation clause, and that would basically inform your data subject that they have the right to have their personal information deleted off your system. Then you need to make sure that the purpose for which you're collecting the data is aligned with the original purpose you stated. However, we'd want to describe the purpose as broadly as possible, not excessively, but when you're thinking why do you want to collect personal information, you want to think as broadly as possible what various things you could do with that personal information and set it out in your terms and conditions. Staff training. You want to make sure that your staff are informed on what your policies are and also that they know how to use the technology to amend, delete, update any of the data on your system. You want to invest in the right technology for data security. As I mentioned, it's very, very important, and there are lots of companies who can assist you in this process. And my last one is direct marketing. Obviously, we know marketing is hugely important for businesses to grow. What's going to happen is the POPI is going to impose a new opt-in system. Currently in South Africa for marketing, when you receive direct communications from various companies, it's completely fine provided a customer has the option to opt out or unsubscribe from receiving those communications. In future, we're going to change to an opt-in system, which basically means you need consent before you can just start directly marketing to clients. And this means, this is an example taken from GDPR in Europe, that basically you can't just go onto LinkedIn, search for people's email addresses on their profiles, or take email addresses from business cards and add it to a mailing list, because they'll be unaware that you're using their personal information to contact them with direct marketing. So yeah, back to our topic, which is the road to economic growth in South Africa. My belief is that the use of data has the potential to help many South African businesses grow, just like the data giants internationally. However, this needs to be done with compliance. Thank you so much for your time, and I hope I provided you with some insight to help your businesses flourish and rise above the rest.